Hello and welcome to the Hardison Cochran podcast. On today's episode, Ben Cochran will be answering another workers' compensation question. And today's question is there any situation where I could be receiving North Carolina workers' comp and be working for another employer separate from the employer that I was working for when I was injured? Now, Ben Cochran.
If you're injured on the job working for, let's say, Company A, and you go and see their treating physician, and that treating physician says that your injuries are so severe that we're going to take you out of work at this time while you heal. And let's say that you're out of work for 6 months. And during this 6 months, the insurance company for that Company A that you were working for when you got injured is going to be providing you temporary total disability benefits on a weekly basis. You cannot go to work for another employer, even if working for the other employer is within your restrictions. Once you start receiving temporary total disability benefits on a weekly basis for being unable to earn wages, you cannot obtain wages from another source. On the back of the temporary total disability check, there is usually a statement or it requests an affirmation that indicates by signing the check, endorsing it, and depositing it in your bank account, you are affirming that you are not receiving any wages from another employer. If you do go get another job for Company B and start making money and also are still receiving temporary total disability benefits from Company A where you were injured, you have committed fraud in North Carolina, because you're signing to one company and receiving monies indicating you're not working, but then you've gotten another job which is paying you, and that is illegal in North Carolina. However, let's say before you got injured, you work for Company A and you work the daytime shift. However, you also have a night shift for Company B. Let's add to that hypothetical that for Company A, it's a heavy-duty, laborious job. You do manual labor for Company A. And for Company B, it's a sedentary position that you work 4 hours or whatever the regiment is in a seated light-duty capacity. If you are injured working for Company A and you can no longer do the heavy intensive labor, then you can start receiving temporary total disability benefits. And if you have light duty restrictions, which are within your physical abilities to do your job at Company B, since you had your job with Company A and Company B at the exact same time when you got injured, then it is possible to continue working for Company B, which is within your restrictions, and receive temporary total disability benefits. That would not be fraud.
Listening to this podcast does not create an attorney-client relationship between you and Hardison Cochran attorneys at law. Hardison Cochran does not accept new clients without first obtaining a signed agreement. The information shared in this podcast is for information purposes and should not be intended or taken as legal advice as to yours or anyone else's legal matter. If you have a legal matter, contact an attorney about your specific set of circumstances.